Good morning. My name is Malik Zanabas Awan, and today I will be presenting a legal analysis of the case involving Autogenius Limited, a private limited company, and its potential exposure to personal liability. In this presentation, I will explain the principle of separate legal personality, the potential for the piercing the veil, and the legal implications for the company's director, Aisha and Billy, who are facing a claim from Netbook Limited for breach of a contract. To start, we have a scenario where Aisha and Billy, both shareholders and directors of Autogenius Limited, are dealing with a breach of contract claim from Netbook Limited. Autogenius was unable to deliver a contract for £1.2 million due to development delays and is now facing insolvency. Today, I will address how the legal principle of separate legal personality applies to this situation, under what circumstances courts may pierce the corporate veil, and the likelihood of Netbook Limited's claim to hold Aisha and Billy personally liable. The principle of separate legal personality means that a company is a distinct legal entity from its shareholders and directors. This was established in the landmark case of Salomon versus Salomon and Co. Limited, 1897. In this case, the House of Lords ruled that once a company is incorporated, it is separate from its shareholders. Even if they are majority owners, this protects the shareholders from personal liability for the company's debt. Talking about this case, in this case, Aisha and Billy, as shareholders of the Autogenius Limited, are not personally liable for the company's £1.2 million debt, as the company itself is a separate entity. Now, let me explain the limited liability. Limited liability means that the shareholders of a company are only liable for the company's debts up to the value of their investment. This is a key factor of the corporate structure. In this case, Aisha holds 70% of the shares and Billy holds 30%. This means that their maximum liability for Autogenius's debts is limited to the value of their shares in the company. Thus, they cannot be personally responsible for the £1.2 million owed to the Netbook Limited unless the corporate veil is pierced. Piercing the corporate veil refers to situations where the court disregards the company's separate legal personality and holds the shareholders or directors personally liable. The conditions for piercing the veil is that it can happen in cases of fraud, improper conduct, or where the company is merely a facade for personal business interests. The court looks at whether the company is being used to avoid legal obligations or hide wrongdoing. Netbook Limited is attempting to pierce the veil by claiming that Autogenius was a facade for Aisha and Billy's personal business interests. However, there is no clear evidence yet to suggest fraud or improper conduct in this case. Talking about the exceptions, we have two major types of exceptions, which are statutory and common law exceptions. Under the statutory exceptions, we have the section 213 to 214 of the Companies Act 2006, which states if fraudulent trading is found, directors can be personally liable. Similarly, under section 238 of Insolvency Act 1986, directors may be held liable for wrongful trading if they continue to trade while the company is insolvent. And talking about the common law exceptions, we got that in Guildford Motor Co. Limited versus Horn 1933, the court pierced the veil because the company was set up to avoid illegal obligations. And in Jones versus Zlipman 1962, the court pierced the veil where the company used to evade a contract. In this case, Autogenius is facing insolvency, but there is no evidence that it was set up to avoid a legal obligation or to conceal personal assets. If we talk about the role of directors and shareholders, Aisha and Billy serves as both directors and shareholders. As directors, they are responsible for the management of the company, including its solvency. As shareholders, they own the company and are entitled to its profits. Their roles do not automatically expose them to personal liability unless they breach their duties, such as acting fraudulent, failing to act in the company's best interest, or mismanaging the company's affairs. Their active involvement in day to day management does not impact their limited liability unless their actions constitute fraudulent or improper conduct. Netbook argues that Autogenius was a facade for Aisha and Billy's personal interests, and thus the corporate veil should be pierced. They claim that Aisha and Billy should be personally liable for the company's death. Although Autogenius is insolvent, the mere fact of insolvency does not warrant the piercing of the veil. There is no evidence of fraud, improper conduct, or abuse of the corporate form in this case. Based on the legal principles, Netbook's attempt to pierce the corporate veil is unlikely to succeed without evidence of fraudulent behavior or a clear attempt to misuse the company's structure. While concluding my arguments, I would like to say that the principle of separate legal personality, as established in Salomon versus Salomon Co. Limited, protects Aisha and Billy from personal liability for Autogenius's debts. Unless Netbook can prove fraud or improper conduct, the corporate veil will likely remain intact. Aisha and Billy are unlikely to be personally liable for the company's debts. Courts will only pierce the corporate veil in cases where the company is facade and there is no evidence of that here. The legal structure of limited liability serves to protect directors and shareholders from personal liability, ensuring that the company's debts do not affect their personal assets unless there's a clear wrongdoing. Thank you.